If I asked most people whether their will controls everything they own, many of them would say yes. That answer feels logical. It feels fair. It feels like the way the world should work. But it is wrong. And in estate planning, being wrong about that one idea can create outcomes that families never intended, courts never stop, and heirs never understand until it is too late. The most assets do not move according to emotion. They do not move according to what feels fair. They do not move according to what your family thinks you meant. They move according to legal structure. That is the machine. And if you do not understand the machine, then even a well-written will can fail to do what you thought it would do. At its core, estate planning is not primarily about documents. It is about control. Who is in control? When does that control change? And how do assets legally move from one person to another? If you can understand those three questions, then wills and trusts become much less mysterious. If you do not understand them, you can sign documents that look official and still leave your family trapped inside a system you did not expect. I want to walk through this slowly because the details matter. When a person dies, the law does not begin by asking what it asks a much narrower set of questions. How was the asset titled? Was there a contract? Was there a beneficiary designation? If none of those apply, does the asset fall into probate? That is the map. There are essentially three ways assets move at death. The first is by contract. Some assets pass automatically because there is a contract attached to them. Retirement accounts, life insurance, payable, on, death accounts, and transfer. On, death accounts often work this way if a beneficiary has been named. When you name a beneficiary, you are not simply writing down a preference. You are creating a binding direction inside the account's legal structure. At death, the contract executes. The money transfers to the named beneficiary. There is no court process needed for that transfer. There is no need for the will to confirm it, and this is the part that surprises many people. If your will says one thing and your beneficiary form says another, the beneficiary form wins. Not sometimes, not usually, it wins. That is because the will does not control assets that already have a valid contractual transfer mechanism. The will only controls assets that fall into probate. The beneficiary designation sits outside that process. This is why beneficiary forms must be reviewed. They are not small administrative details. They are controlled documents. If you named a sibling on a life insurance policy 20 years ago and later wrote a will leaving everything to your children, the life insurance still goes to the sibling unless you change the beneficiary form. Your family may say, that is not what was intended. The court may understand the frustration, but the structure controls. The second way assets move is by title. Title means the ownership structure of the asset itself. If two people own a home jointly with rights of survivorship, the surviving owner automatically becomes the full owner when one person dies. That happens because of title. It does not happen because of the will. The same can be true for joint bank accounts and other jointly titled property. If the title includes survivorship rights, the asset passes to the surviving owner by operation of law. Again, the will does not override this. Think about the second marriage problem. A person owns a home jointly with a current spouse, but the will says that their share of the home should go to a child from a prior marriage. Emotionally, that may seem clear. Legally, it may not matter. If the title says joint ownership with rights of survivorship, the surviving spouse becomes the full owner at death. The child may receive nothing from that home, even if the will says something different. No one is ignoring the will. The will simply never had control over that asset. Ownership structure came first. This is how unintended outcomes happen. Not because people are careless. Often they are trying to do the right thing, but they do not understand which legal mechanism is actually in control. The third way assets move is through probate. Probate is the court-supervised process for transferring assets after death. If an asset has no beneficiary designation, no survivorship feature, and is not owned by a trust, then it may become a probate asset. And here is the key distinction. A will only controls probate assets. That sentence is one of the most important sentences in estate planning. A will does not control assets passing by contract. A will does not control assets passing by title. A will controls what is left in the probate bucket. That is why a person can have a will and still have major assets pass in a way the will never touched. If the retirement account has a beneficiary, the contract controls. If the house is jointly titled with survivorship, title controls. If an individual bank account has no beneficiary and no joint owner, the will may control it through probate. So estate planning begins by identifying what bucket each asset sits in: contract, title, probate. Without that, people are simply guessing. Now let us talk about the will itself. A will is a revocable legal document. Revocable means you can change it while you are alive and competent, but a will has no legal effect while you are alive. It does not manage your money. It does not transfer your assets. It does not protect you during incapacity. It simply sits there until death. At death, it becomes operative. Its main function is to direct the distribution of probate assets. That is all. It is very important, but it is narrower than people think. A will does not avoid probate. In fact, a will is usually the thing that begins the probate process. After death, the will is submitted to the court, and the court supervises the administration of the estate. That is not a flaw. That is what a will is designed to do. It operates within the court system. A will can name an executor. The executor is the person responsible for carrying out the instructions in the will. The executor gathers assets, works with the court, pays valid debts and final expenses, handles taxes when needed, and distributes the remaining probate assets according to the will. Think of the executor as the administrator of the estate. The executor does not own the assets personally. The executor carries out the plan through the legal process. A will can also name guardians for minor children. This is critical. If you have minor children, a will is not optional. It is the document where you nominate the person you would want to raise them if something happened to you. A trust cannot do that. A beneficiary form cannot do that. A joint account cannot do that. The court ultimately appoints the guardian, but your will is the place where your wishes are formally expressed. In most ordinary situations, courts give strong weight to that nomination. Without a will, that decision is left much more exposed to the court process. So even people with trusts often still need a will, especially if they have minor children. A will can also direct probate assets to beneficiaries. It can say who gets what among the assets that fall under probate. But here is what a will cannot do. It cannot override beneficiary designations. It cannot override joint ownership with survivorship. It cannot avoid probate. It cannot reduce estate taxes simply by existing. It cannot protect assets from creditors, simply because the document says who should receive them. And it cannot manage your assets if you are incapacitated, because it only operates after death. This is why I think of a will as a basic but limited instrument. It is necessary for many people. It is powerful in its lane, but it does not control the whole road. Now consider a simple example. A person dies with a will that says everything goes to their children. That same person has a life insurance policy naming a sibling as beneficiary. They also own a house jointly with a spouse. What happens? The life insurance goes to the sibling because the beneficiary form controls. The house goes to the spouse because the title controls. The will controls only the remaining probate assets. The children may feel the will was clear, but the system follows structure, not emotion. That is why estate planning has to be done asset by asset, not only document by document. A beautifully drafted will can still fail to control the assets you assumed it controlled if those assets are already moving by contract or title. Now let us turn to trusts. A trust is not just a document. It is a legal relationship. A trust exists when a grantor transfers property to a trustee to be managed for the benefit of beneficiaries. The grantor creates the trust or transfers assets into it. The trustee manages the assets. The beneficiaries receive the benefit. The essential concept is that a trust separates legal ownership from beneficial ownership. In simple terms, one person or entity can manage and legally control the asset while another person benefits from it. That separation is the reason trusts exist. It allows you to create rules for how assets are managed, when distributions happen, who has control, and what happens if circumstances change. Trusts are about continuity, timing, privacy, incapacity planning, and managing complexity. And when a revocable living trust is properly structured and properly funded, it can keep assets out of probate. That is one of its main practical benefits. Probate is public. Trust administration is generally private. Probate is supervised by a court. Trust administration can usually happen without the same court involvement. For many families, privacy and continuity matter. But the phrase properly funded is not a small detail. It is the difference between a trust that works and a trust that is just paper. A trust only controls assets that are titled to it or directed to flow into it. If you create a trust but leave your house, accounts, and other assets in your individual name without any transfer mechanism, then those assets may still go through probate. People sometimes say, "I have a trust, so I avoid probate." That statement is incomplete. You avoid probate only to the extent assets have been properly placed under the trust structure or directed into it. A trust document sitting in a drawer does not move assets by magic. Funding the trust is the work. There are two broad trust categories most people encounter. A living trust is created during your lifetime. It can be revocable or irrevocable. It can operate while you are alive, during incapacity, and after death. When people casually say, "I have a trust," they are usually referring to a living trust, most often a revocable living trust. A testamentary trust is different. It is created inside a will. It does not exist while you are alive. It comes into existence only at death through the probate process. That means a testamentary trust does not avoid probate. It is born from probate. Its benefit is not probate avoidance. Its benefit is post-death control. For example, if you have minor children or beneficiaries who are not ready to receive assets outright, a testamentary trust can hold assets for them after death. It can say assets may be used for health, education, maintenance, and support, and then distributed later, perhaps at a certain age. This can be valuable. But it does not avoid court involvement at the front end because it is created by a will that goes through probate. So you have to know what problem you are trying to solve. If the problem is, "I want to control distributions after my death," a testamentary trust may help. If the problem is, "I want to avoid probate and manage incapacity privately," a revocable living trust may be the better tool. Now let us compare a revocable living trust with a will, because this is the decision many families are really trying to understand. A revocable living trust is created during your life. While you are alive and competent, you can remain in control, you can serve as your own trustee, you can manage your money, you can buy and sell property, you can change the trust, you can revoke it. Day to day, life may feel the same, but the structure is different. If assets are titled to the trust owns them. You control the trust, but the legal structure is in place. At death, a successor trustee can step in and administer the trust privately. According to the instructions in the trust document during incapacity, the successor trustee can also step in. That is one of the strongest arguments for a revocable trust. Estate planning is not only about death, it is also about what happens if you are alive but unable to act. This is a major risk. A person may suffer a stroke, develop dementia, experience a severe illness, or become unable to manage financial affairs. If there is no effective structure, the family may have to petition a court for guardianship or conservatorship. That can take time. It can require medical records. It can require hearings. It can create a painful limbo period when bills need to be paid and decisions need to be made, but no one has clear authority. A durable financial power of attorney can help. Every adult should consider having one. It allows someone to act on your behalf if you cannot act. But powers of attorney have practical weaknesses. Financial institutions may question them. They may reject them. They may require their own forms. They may work account by account. A revocable trust functions differently for assets already held by the trust. The successor trustee does not need to ask to act as your agent over those assets. The trustee steps into an existing role inside an existing structure. That can reduce friction during a crisis. If you recover, control can return to you. If incapacity continues, the successor trustee continues managing according to your instructions. This is why I see trusts as continuity tools. They do not make life risk disappear. They make the transition of control more orderly. A revocable trust also creates privacy. Probate filings can become public records. A will submitted to court can reveal who inherits, who serves as executor, and sometimes the broad outline of the estate. Trust administration is generally private. For some families, that matters deeply. For others, it may not matter much, but if privacy is a priority, a trust can solve a real problem. Now we need to be clear about what a revocable trust does not do. A revocable living trust does not reduce estate taxes. It does not remove assets from your taxable estate. It does not protect assets from your creditors in the way many people imagine. Why? Because you retain control. Control and taxation are connected. If you can revoke the trust, change it, control the assets, and benefit from the assets, the tax system generally treats them as still yours. That means a revocable trust is mainly an administration strategy, not a tax strategy. It is about avoiding probate, creating privacy, and managing continuity during incapacity and after death. It does not make your estate smaller for tax purposes. If estate tax reduction, asset protection, Medicaid planning, or advanced wealth transfer is the goal, then the conversation may move toward irrevocable trusts. But irrevocable trusts are fundamentally different. With an irrevocable trust, you usually give up control. That is the price of the potential benefit. Because you give up control, some irrevocable trusts can provide estate tax benefits, creditor protection, long-term care planning benefits, or advanced transfer strategies. But the trade-off is real. You no longer have the same freedom over the assets. That is why irrevocable trusts are used in more advanced planning and are not the everyday default for every family. Most middle-class families first need to understand the difference between a will and a revocable living trust. That is the core decision for many households. A will is simpler and often less expensive. It names an executor, directs probate assets, and nominates guardians for minor children. It is essential for certain situations, but it requires probate. It does not function during incapacity. And once submitted to court, it becomes part of a public process. A revocable living trust is usually more expensive and requires more administrative work. Assets have to be retitled. The plan has to be maintained. The structure has to be kept aligned with reality, but it can avoid probate for funded assets. It can function during incapacity. It can keep administration private. Neither tool is automatically better in every situation. The right answer depends on the family system, the asset structure, the state law, the cost of probate, the need for privacy, the risk of incapacity, and the complexity of beneficiaries. This is how I would think about it. A will equals death, probate, and public process. It activates at death. It enters the court system. It becomes part of a public record once submitted. A revocable trust equals life, incapacity, and privacy. It can operate while you are alive. It can allow a successor trustee to act during incapacity. It can transfer assets privately after death if properly funded. That mental model is not perfect, but it is useful. It helps you remember the structural difference. Now let us clear up some common myths. The first myth is that trusts avoid taxes. Revocable trusts do not. If you retain, the IRS still treats the assets as yours. They remain in your estate. They do not create tax avoidance just because they are inside a revocable trust. Certain irrevocable trusts may have tax advantages, but that is because control has been given up. When someone says a trust avoids taxes, the first question should be, what kind of trust? The second myth is that having a trust automatically avoids probate. Only funded trusts avoid probate for the assets they control. Creating the trust is step one. Funding it is step two. If an asset remains in your individual name with no beneficiary designation and no trust ownership, it may still go through probate. Without funding, the trust is paper. With funding, it becomes a structure. The third myth is that a will controls everything. It does not. It controls probate assets. It does not override beneficiary forms. It does not override joint title. It does not override transfer on death or payable on death arrangements. This is one of the largest mistake areas because people assume the will is the master document. In reality, beneficiary designations and title can override what people think their will says. The fourth myth is that testamentary trusts avoid probate. They do not. A testamentary trust is created through a will. It exists because probate happened. It can control assets after death, but it is not a probate avoidance strategy. The common pattern in all these myths is misunderstanding structure. Estate planning is not primarily about the document name. It is about which legal mechanism controls which asset at which moment. Now let us talk more about guardianship, because it is so important. If you have minor children, you need a will, even if you have a trust. Even if your assets are titled perfectly, even if your beneficiary forms are updated, only a will can nominate a guardian for minor children. That means the question for parents is often not will or trust. It is both. The trust may manage assets and avoid probate. The will nominates guardians and may serve as a backup for assets not placed into the trust. This backup role is sometimes handled by a pour-over will, which directs any probate assets into the trust after death. But even then, assets that were not placed in the trust may still have to pass through probate first. So the trust and will can work together, but they do different jobs. The right estate plan is not about choosing the fanciest document. It is about coordinating the tools so the structure matches reality. Now, when is a will enough? For some people, a will may be entirely sufficient. If your estate is simple, if most assets pass by beneficiary designation, if there is no complicated real estate situation, if your state has a manageable probate process, if family dynamics are straightforward, and if you have strong, durable powers of attorney and healthcare directives for incapacity, then a will may be enough. Not everyone needs a trust. Trusts cost more to draft. They require maintenance. Assets need to be retitled. The family has to understand the structure. If the problem you are solving is simple, a simpler tool may be appropriate. A well-drafted will, updated beneficiary designations, proper account titling, durable financial power of attorney, healthcare power of attorney, and an advance directive can form a strong basic plan for many people. But when does a revocable living trust make sense? It makes sense when it solves a real problem. If your state's probate process is slow, costly, or burdensome, a trust can reduce that burden. If privacy matters, a trust can help. If you own property in multiple states, a trust can be especially useful because otherwise your estate might require probate in more than one state. A trust can consolidate administration under one structure. If incapacity planning is a major concern, a trust can provide continuity if you have a blended family, a second marriage, children from prior relationships, beneficiaries who should not receive assets outright, or a need to stagger distributions. A trust can provide rules. It can say when assets are distributed, it can provide for a surviving spouse while preserving assets for children. It can protect a young beneficiary from receiving too much too soon. It can create a framework for long-term management. Trusts shine where complexity exists. They allow structure, but structure is only valuable if it is aligned with your goals and actually implemented. Now let us talk about incapacity planning as a separate issue because many people forget it. When someone becomes incapacitated, there are generally 3 ways someone else can step in. The first is court appointment of a guardian or conservator. This can be slow, expensive, stressful, and public. The second is a durable power of attorney. This can be very helpful, but it depends on whether institutions accept it and whether it covers the needed authority. The third is a successor trustee under a revocable trust. For assets inside the trust, the successor trustee can step into an existing role and manage according to the trust terms. A good plan often uses all the necessary tools together: a revocable trust for trust assets, a durable financial power of attorney for assets or matters outside the trust, a healthcare power of attorney for medical decisions, a living will or advance directive for end-of-life medical preferences. These documents are not competitors. They are a system. If one part is missing, the family may still face friction. If all parts are coordinated, the transition becomes clearer. That is the purpose of planning. It does not remove grief. It removes avoidable chaos. And this matters because chaos during crisis is expensive. It creates conflict, it delays decisions, it forces families into court, it exposes private details, it can freeze accounts, it can leave bills unpaid, it can make a painful moment harder than it has to be. The goal is to reduce friction before the hard moment arrives. Estate planning is also about keeping the legal structure aligned with your life as it changes. People get married, people divorce. Children are born, children become adults. Beneficiaries die, relationships change, assets are sold, new accounts are opened, homes are retitled, retirement accounts are rolled over. If the documents are old and the beneficiary forms are newer, the newer forms may control. If title does not match the plan, the title may override the plan. If the trust is created but assets were never funded into it, the trust may not do what the family expects. So estate planning is not a one-time emotional project. It is a structure that should be reviewed. You do not have to review it every week. But major life events should trigger a review, and periodically you should confirm that the structure still matches the intention. The central question is not, do I have documents? The central question is, does the legal structure move control and assets the way I intend when I am alive, incapacitated, and dead? That is the question that matters. Because a will may say the children inherit everything, while the beneficiary form sends the life insurance to someone else. A trust may say the successor trustee can manage assets while the assets themselves were never placed in the trust. A parent may believe a child will receive a share of the home, while joint title sends the entire home to a surviving spouse. A person may think they avoided probate, while a forgotten account remains in individual name and goes through probate anyway. These are not rare mistakes, they are structural mismatches, and mismatches create unintended consequences. In my own framework, I would approach estate planning the same way I approach any complex system. First, identify the assets. Second, identify how each asset is titled. Third, identify whether each asset has a beneficiary designation or contractual transfer mechanism. Fourth, identify which assets would fall into probate. Fifth, decide whether probate is acceptable or should be avoided. Sixth, plan for incapacity, not just death. Seventh, coordinate the documents. Eighth, review the structure over time. That is a principles-based way to think about it. The specific legal documents should be drafted by a qualified estate planning attorney in your state because state law matters. But the mental model is universal. Control, timing, transfer. Those are the three questions. Who controls the asset now? Who controls it if you are incapacitated? Who controls it after you die? When does that control change? And by what legal mechanism does the asset move? If you can answer those questions for every major asset you own, you are far ahead of most people. Now let me make one final distinction. Estate planning is not only for wealthy people. A person with enormous wealth needs estate planning, but so does a middle-class family with a home, a retirement account, life insurance, and children. The reason is that estate planning is not only about tax. Many people hear estate planning and immediately think of estate taxes. But most families are not dealing with estate tax. They are dealing with probate, incapacity, guardianship, beneficiary mistakes, family conflict, and administrative burden. Those issues do not require a giant estate. They only require assets, family, and the possibility of illness or death. That is why almost every adult should have some form of estate plan. For some people, that plan is a will, updated beneficiaries, powers of attorney, and healthcare directives. For others, it includes a revocable living trust. For some with larger estates, creditor concerns, Medicaid planning issues, business succession, or advanced tax planning, irrevocable trust strategies may be appropriate. But the first step is not buying a document. The first step is understanding the structure. When you understand structure, you can ask better questions. You can sit down with an attorney and say, here are my assets. Here is how they are titled. Here are the beneficiaries. Here is my family situation. Here is my concern about incapacity. Here is what I want to happen. What structure best solves these problems? That is a much better conversation than simply, do I need a will or a trust? The better question is, what problem am I trying to solve? And which structure actually solves it? That is how you avoid paying for documents that do not match your life. That is how you prevent the legal system from following paperwork that contradicts your intention. That is how you make one of life's hardest moments easier for the people you love. A will can be necessary. A trust can be powerful. A power of attorney can be essential. A healthcare directive can prevent confusion. Beneficiary designations can control large parts of your estate. Title can override your wishes if you do not structure it correctly. All of these pieces work together, or they conflict. That is the choice. Most people think estate planning is about what happens after death. That is only part of it. The better way to think is this. Estate planning is how you design control for the moments when you cannot personally exercise it. While you are alive and capable, you control your assets. If you become incapacitated, someone needs legal authority to step in. When you die, assets need to move according to structure, not confusion. The goal is to make those transitions orderly. That is what good planning does. It does not make mortality less real. It does not make family emotions disappear, but it does reduce avoidable damage. And that matters, because when a family is grieving or frightened, the last thing they need is to discover that the will does not control the life insurance. The house passed to the wrong person by title. The trust was never funded. The bank will not accept the power of attorney, or the court process will take months before anyone can act. Those problems are preventable, but only if you understand the rules before the event happens. So do not ask only whether you have a will. Ask what your will actually controls. Do not ask only whether you have a trust. Ask whether it is funded. Do not assume your beneficiary forms are right. Do not assume joint ownership reflects your true intention. Review the title. Do not assume incapacity will be handled naturally by the family. Put authority in place, and if you have children, do not leave guardianship to chance. Name the guardian in a will. That is the structure. That is the system. And once you understand it, the whole subject becomes less frightening. It becomes a design problem. Who controls? When does control change? How do assets move? Those three questions are the beginning of real estate planning. Everything else is paperwork built around those answers.